Thank you very much for hopping on the line today to learn a little bit more about estate planning and pet trusts. My name is Jennifer Gross. I am Director of Philanthropy with SPCA Tampa Bay, and I work with a lot of our donors. So it's possible that our paths have crossed. If not, I hope they will. So joining us today, our featured speaker today, I'll give her a quick intro and then I'll let her tell us a little bit more about herself. Stephanie Edwards founded Edwards Elder Law in St. Pete to provide seniors and their families with legal services to address immediate care concerns, proactively plan for the future, and cope with things that come up during times of crisis. Stephanie's main practice areas include estate planning, wills and trusts, probate and trust administration, incapacity planning, Medicaid, long-term care benefits, VA aid, and attendance benefits. And of course, very important to us, in addition to being an accomplished elder law attorney in St. Petersburg, Stephanie is also the proud mom of two adoring felines. So with all that, I'm going to turn it over to you, Stephanie, and let us get us started.
Oh, thank you. Well, actually, I am now the proud mom of four felines because we have two kittens living at the office now who just knocked a plant off the windowsill, which I'm very happy happened before the seminar, not during the seminar.
Well, good. Do you want to share their names?
Oh, Zoe and Zach.
Zoe and Zach. Very nice.
So I don't think they'll make a cameo because they're hiding under the table right now from their little scare. but so yes, as probably most of y'all are, I am a pet owner, and we worry about our pets. We don't like to think that something is going to happen to us that's going to leave our pets homeless, but sometimes things that we don't want to happen, and so they are important members of our family to plan for. So what I'm going to do, I'm going to talk to you a little bit about the estate planning experience in general. And then I'm going to leave plenty of time for Jennifer to be able to talk about the SPCA's Legacy of Love Pet Trust, because that's really kind of the main attraction for today. So when we talk about estate planning, we have to talk about what are the plans we need to put in place in case we're alive but incapacitated, and then what are the plans that we want to put in place in case we pass away. So we always start with incapacity first, because it is more likely that you're going to experience an unexpected incapacity than that you're going to experience an unexpected death. So incapacity planning is really important because we want to take care of you first. So when we look on the incapacity side, we say, all right, there's three documents that we look at. We look at the designation of healthcare surrogate. That's the person who's going to make medical decisions for you in case you can't. We then look at the living will, and the living will's only job is to say whether you do or you don't want to be kept alive artificially. And then we look at the durable power of attorney, which is the person that handles everything else that's not medical. Now, if you have a trust, there's a little asterisk to that, but we're just going to try to stay with the generalities here. So the designation of healthcare surrogate. Oh, here we go. We're in column number 1. the documents that speak for you while you're alive. So designation of healthcare surrogate. This is the one who's going to talk to the doctor, make medical decisions for you. It's probably the hardest job of any of the jobs that you need to give to somebody, because this person has to make really difficult decisions in a really highly emotional time. It needs to be somebody who's not going to be scared to go running after the doctor down the hall and say, okay, I'm not done yet, I still have questions, come back here. So that this person is charged with making all of those medical decisions. Sometimes people want this person to be a family member. Sometimes people don't want this person to be a family member. Some family members might say, yeah, this is too emotional of a job for me. I don't want to make these decisions. I want to be there. I want to support you. I want to be involved, but I don't want the responsibility of this position. So in deciding who should speak for you, it's really important that you chat with them ahead of time and say, is this a job that you feel comfortable accepting? It's really hard when they find out right at the time of the event, and they get a phone call from the hospital that says, okay, you're in charge, and they haven't had a chance to prepare. They haven't had a chance to chat with you, to understand what kind of medical decisions you would want them to make for you. What's your definition of quality of life? So here we are with our handout, which I have to say, I'm very excited that I am not in charge of the handouts, because if I was in charge of getting the handout on the screen, it might not be happening at all. So thank you, Jen, for getting our handout there.
Forgive me. We made it. We made it.
We did.
Sorry for that poor driving to start.
So we're in column number 1. The document says speak for you while you're alive, but don't speak for you once you pass away. Their job is to take care of you in case of incapacity. So that's the healthcare surrogate that we've been talking about. Now, as the living will, I kind of think of the living will as kind of like a subset of the healthcare surrogate, because the living will's only job is to say that you do or you don't want to be kept alive artificially, so that when the doctor asks your healthcare surrogate to make that decision, your healthcare surrogate has an idea of what you would want. What's your definition of quality of life. Now, the living will gets confused, it gets jumbled sometimes with the do not resuscitate order. So they are two entirely different things. The do not resuscitate order you can only get from your doctor. You can't get it from the attorney. It's a discussion with your doctor, in which then your doctor completes in essence, a doctor's order that says that you do not want CPR, and it's on this yellow piece of paper, and that yellow piece of paper is really important, because that is the only thing that signifies and sort of verifies that you have this do not resuscitate order in place. So if you have a DNR, a do not resuscitate, and you're at home and you have a heart attack and your family calls 911 and they come in to treat you, if you have a DNR on this yellow piece of paper, they are able to respect that, and they won't give you CPR. If all you have is the living will, which captures your wishes, but it's not a doctor's order, 911 can't refuse to or abstain from giving you treatment because you have a living will. They are going to err on the side of giving you CPR, and they're going to say, take that living will with you to the hospital, and then they're going to look at it there. But 911 can only withhold treatment based upon the do not resuscitate, not based upon the living will. But the living will is a broader way to capture your end of life decisions than the DNR. The DNR is, I don't want to have CPR, basically. The living will is saying, look, if two doctors tell you that this treatment they're about to give me, usually putting you on a ventilator, is not going to lead to me having any type of recovery. I'm going to be put on this ventilator. I'm never coming off. I'm not going to recover. I'm not going to have the quality of life that I want. At that point, I don't want that type of treatment. Sometimes people get really nervous about putting a living will in place because they say, okay, I don't want to be kept alive indefinitely on a breathing machine if I have no hope of recovery, but I really don't want people to be too eager to decide that, yeah, I have no hope for recovery. It's really, although it can be a little nerve-wracking to think about it, it doesn't get triggered until two doctors agree that there is no hope for your recovery. So if you're in a car accident, if you have a living will and you're in a car accident and putting you on a ventilator on a temporary basis is going to help you recover, that's what's going to happen. You having a living will is not going to prevent that from happening. The living will is only going to speak once the two doctors have agreed that there's not really a chance for you to have a recovery. So I always get lots of questions about the DNR versus the living will. And as we go along, speaking of questions, if you have questions, please feel free to either put them in the chat box or put them in the Q&A, and Jen will help help me see them, because I'm not a believer that you have to hold your questions until the end. In the absence of questions, y'all will get me just kind of telling you what I think you want to hear. But since you've taken the time to be here, we do want to make sure that you get to hear, something. If you have a specific question in mind, we want you to have the chance to ask that.
And I did just check, Stephanie. I do not see any questions that have come in through Q&A or chat. So
Okay.
Everything must be crystal clear.
So far, so good.
Yes.
Okay, so a lot of times people will come in and they'll say, I don't have a healthcare surrogate. I haven't filled out a healthcare surrogate form. It's not that you don't have a healthcare surrogate. It's that you have the state of Florida default option. With everything, the healthcare surrogate, the durable power of attorney, the will, if you haven't taken affirmative action to put your own wishes in place, the state of Florida has a default option because somebody's making medical decisions for you, somebody's taking care of your finances, somebody's inheriting the stuff that you own. It's just a matter of, is that person who the state of Florida thinks is the appropriate person, or is it the person that you've chosen? So if you haven't put your healthcare surrogate in place, the state of Florida has a chart, and it will go to your spouse first. And most people, unless you have a spouse that says, oh, that's too emotional of a job for me, most people are saying, okay, yeah, that's kind of what I would want. I would want my spouse to be first. Things always get a little more confusing on the in the situation where your spouse was in the same car accident as you were, and now you're both in the emergency room, because then the default option goes down to your children, and it goes down to your children equally. So if you have more than one child, now you've got more than one person with the same priority to make healthcare decisions for you. And if your children never disagree about anything, then that's kind of okay. But most of us, no matter how well we get along with our siblings, you throw us in the emotional situation of what kind of healthcare treatment should mom or dad get, and it's just a situation ripe for disagreements. So by putting your own healthcare surrogate in place, you can say, look, I want all my kids to be involved or not. You know, sometimes you may not, but here's the order of the person who has the authority to speak for me. It's this person second, this person third, this person fourth. So then that way there's never any confusion with the doctors about who is communicating the decision for your healthcare. Because if you have more than one person with equal priority to make a decision and they don't agree, well, now it's going to court, and you've got the court involved in kind of breaking the tie, and that's usually not what anybody wants. So you get the ability to try to preserve some of your family harmony by putting your choices in your healthcare surrogate and not having to rely on the state of Florida default option. Then the next question that comes up is, okay, I have more than one child, so how do I put one of them in charge without hurting the other one's feelings? And for a lot of parents, the default option is, I'm just going to name the oldest child. I'm going to name everybody in birth order. That's how it's going to go down. And I can tell you, as an oldest child, that, you know, as an oldest child, that sounds like a perfectly good plan. I'm like, of course I should be in charge. You know, I'm the oldest. I've done everything first. Yeah, that means I do it the best. But unfortunately, it's not really quite that simple. Your oldest child may or may not be the best person for this healthcare surrogate position, because you really want to look at who is going to be able to handle this really emotional job, and remember what you want and not what they want. So that could be your oldest child, that could be your youngest child, it could be, you know, one of your children in between. So whoever you choose, definitely meet with your family, meet with your other children, and say, this is why I chose this person. Oh, and I think we have a question.
We do. Stephanie,
Yay.
it looks like Deanna is wanting to know how the decision making is completed with blended families. Is it his children, her children, or both?
It's so under the default option, it's going to be biological children. So in a blended family, your stepchildren are probably not going to, they could come into play, because after it goes through spouse and children and siblings and et cetera, in Florida, then it gets to friends or, you know, other family members that have a special relationship with you. But the default option is first going to go to your biological children. I'll check that for you, because I haven't, that's not one that a question that I typically answer off the top of my head. So I'm about 99% sure that that's the answer, but I will check the statute for you and make sure. And I can work with Jen to get you an answer, but I think it's just your biological children. All right, did that? If that didn't answer your question, feel free to continue with your question and answer, and we'll stop again and go there. So, any other questions before we leave the medical world and go into the durable power of attorney world?
It looks like that is the only question that has come in so far, Stephanie, but I will keep an eye on that chat box and that Q&A box for more.
Okay. All right. So after we deal with the medical, now the durable power of attorney steps in and handles everything else that's non-medical. Now, keep in mind, I kind of said, if you have a trust, then the durable power of attorney handles anything that you own outside of the trust. The trustee of the trust handles what's in the trust, but we're going to try to keep things kind of streamlined for today. So in general, we're going to say the durable power of attorney handles everything else that's not a medical decision for you. So this is the person who has access to your bank account. This is the person who has access to your mail. This is the person who can file your tax returns. This is the person who's basically making any decision that you would make that is not a medical decision. So this is a really big job, and it all comes down to picking somebody that you trust. Because if you can take all the money out of your bank account and take a splurge trip to Tahiti, so can they. So it has to be somebody that you believe is not going to have an issue doing what's in your best interest. The different thing about the durable power of attorney versus the healthcare surrogate is, we were talking a minute ago about if you haven't affirmatively put a healthcare surrogate in place and you've got the state of Florida default option, the state of Florida has got that list that says in what order people can speak for you. Under the durable power of attorney, that's not the default option. It does not default to family members like the healthcare surrogate does. If you don't put a durable power of attorney in place, it is going to default to guardianship court. And then everybody, including your spouse, just because they're your spouse, they don't get to automatically do this job. Everybody is going to have to go to guardianship court and talk to the judge and explain why they think that they should be the best person to be appointed the guardian for you. And then the guardian is overseen by the judge to make sure that the guardian is acting in your best interest. So if you don't have someone that you trust absolutely, completely, I mean, you can have family members who are lovely people, but terrible with money that you would never want to put in this position. If that's your situation, having a guardian appointed who's overseen by the court can actually be a better answer than putting a family member that you're not sure if this is the right person to act on your behalf, because the durable power of attorney is not supervised by anybody, which is why you need to pick the person that you trust. So guardianship can be an unwelcome surprise to, in most cases, a spouse who just feels like, because it's a partnership and the spouses just step in for each other, that they're going to step in and handle these non-medical decisions for you. And it can be an unwelcome surprise when they find out that that's not the way it works unless you have taken the affirmative step to put this durable power of attorney in place. Okay, oh, I can see this one. So the question is, the durable power of attorney and the healthcare surrogate in the same document. It's most likely, is your document a Florida document or from a different state? Because Florida, so that's interesting. It's the same person. Think of these as hats. Think of it as the healthcare surrogate hat and the durable power of attorney hat. The same person can wear both hats. Typically, the hats are two separate documents. I have seen them sometimes combined. It doesn't mean that they don't work combined. So it's perfectly fine. Don't panic and think that it's not. It's my personal preference is that they not be in the same document, even if you're naming the same person, because the durable power of attorney documents are long, which we'll talk about in a minute as to why they're long. And the healthcare surrogate document is short and sweet, because when you're in the hospital and they're trying to establish who's the healthcare surrogate, you don't want them to have to be flipping through all these pages trying to find the answer. You want it to be kind of short and sweet. Here it is. This is the person who's in charge. So my personal preference is that they get appointed to these two separate jobs with two separate documents. but I have seen the same person appointed to both jobs in the same document before. I'm assuming that what you have is fine. I mean, I'd have to take a look at it, but there's not anything that says it has to be in two separate documents. The reason the durable power of attorney is long is because if you have a durable power of attorney in place, you want to pull it out and you want to see, did you sign it before or after October 1st, 2011? That's the magic date in Florida, October 1st, 2011, because the durable power of attorney law changed dramatically as of that date. So pre-October 1st, 2011, the durable power of attorney documents tended to be much shorter because we were able, in essence, to use this paragraph, this general paragraph that said, okay, this person's me. If I can do it, they can do it. And maybe just by way of example, we would say, take care of my bank account, take care of my house. But we didn't have to list everything because we had that general paragraph that said, this person's me. And they can do whatever I can do. The legislature, the Florida legislature, decided they didn't like that general paragraph because when we think about somebody being us and doing anything that we can do in a time that we're incapacitated, it's human nature to think that the time that we're incapacitated is just going to be a temporary blip. We had an operation, we were in a car accident, but we're kind of expecting this durable power of attorney to come in, maintain the status quo, take care of everything, keep all the plates spinning, and then give everything back to us when we recover from this temporary incapacity. But sometimes the incapacity is not temporary. And the longer the incapacity period, the more likely that the durable power of attorney now is going to have to start rearranging the way that you own things, because we probably need access to money to be paying medical or long-term care bills. And we don't typically think of this durable power of attorney having the power to sell our house, clean out our bank account, change our beneficiaries, those types of things. So because that's not what we tend to think about when we just have a general paragraph that says this person can do anything we can do, the legislature changed the whole durable power of attorney law as of October 1st, 2011. And now there are 15 different activities, mostly the activities that involve rearranging the way that we own things, that have to be specifically initialed. We can no longer use a general paragraph that says this person's me and they can do anything I can do. Everything has to be listed specifically, and these 15 different activities also have to be initialed by you. And if they're not, if the activity is not listed specifically, the agent can't do it. And if it's one of these activities that has to be initialed and it's not initialed, the agent can't do it. And if we need the agent to do something that the durable power of attorney doesn't authorize, now everybody has to go to guardianship court to have a guardian appointed to do that activity that the durable power of attorney didn't authorize. So if you have a durable power of attorney from before October 1st, 2011, you really want to have it reviewed by an elder law attorney, estate planning attorney, somebody who works in this area, because I have a lot of people that come in now and they got their durable power of attorney from 1995, which worked great in 1995, but really doesn't do much for them in 2020 because it just has that general paragraph, doesn't have very much listed specifically. And now we're just stuck with those little things that were listed specifically that were never meant to be a comprehensive list. So my biggest takeaway message from all of this, other than the pet trust that you're going to hear about in a few minutes, is look at the date on your durable power of attorney. And if it's pre-October 1st, 2011, have it looked at, because you've got a hole in your security blanket. You know, you're thinking, gosh, you know, I was good, I took action, I've put, you know, healthcare surrogate, living will, durable power of attorney in place. I'm not stuck with any of the default options. And then we find out when it's too late for you to update it, that it actually was not what you needed. So that's the important thing. Okay, any questions about column number 1, healthcare surrogate, living will, durable power of attorney, before we jump over to column number 3 and talk about your will? All right, I think everybody looks like they're good from what
I have not seen any additional questions come in through that Q&A box, but just a reminder, folks, you can use the Q&A box or the chat box to send Stephanie questions.
Okay, so the will, just like the healthcare surrogate and the durable power of attorney, you have the option to put your own thoughts in place, or in the absence of your own thoughts, there's going to be a state of Florida default option. So column number 3, your will has no job to do for you until you pass away. So while you're alive, you can have a will that you've put in place, but it has no job to do until you pass away, because you can always change your mind as long as you've got capacity. Once you pass away, anybody who had authority through a document in column number 1, the healthcare surrogate, the durable power of attorney, they no longer have authority. Those documents only work as long as you're alive. We'll have people that'll come in after their family members passed away, and they'll say, okay, I'm the durable power of attorney. I think I can still do X, Y, and Z. And we have to say, gosh, you can't do anything, because the authority that you had ended when the person who gave it to you passed away. And now we have to look to the will. Now, the important thing about the will is not everything that you own when you pass away is going to get instructions from your will. So when we go to put your will together, kind of the first thing we have to do is we have to give you a little bit of homework, in which we have you gather together information about what you own, because you can own things in one of 4 ways. And the way that you own it determines where it's going to get instructions from when you pass away. So for example, if you own something jointly with someone else, a married couple owns a house together. With a married couple, usually there are built-in survivorship rights. So when you buy that house together as a married couple, built into the deed, the instrument in which you bought the house, is a built-in instruction that says when the first spouse passes away, the second spouse automatically owns this house. So that's a survivorship right. We don't have to look to the will to find out what's going to happen to that house, because that house has got a built-in instruction saying, go to the surviving spouse. Now, if you own the house with someone who's not your surviving spouse, you can't just assume that there's survivorship language. You actually have to look at the deed. You have to look at the bank account. You have to look at whatever it is that you own jointly with someone who's not your spouse. And we have to specifically see survivorship language. So that's the first thing we do. We say, is there a built-in direction that it goes to the surviving joint owner? If the answer is yes, then we stop there, because it's going to the surviving joint owner. If the answer is no, then it's going to get instructions from the will, which we'll talk about in a second. The second column that we look at, so we always look for joint property with survivorship rights first. Then we look for things that you've put a beneficiary designation on. So typically life insurance, IRAs, retirement accounts, in which you filled out a piece of paper that said, if I pass away, I want this to go to, Susie. If that beneficiary form has instructions that says this is going to Susie, it's going to Susie. It never makes it to the will to get instructions from the will, because it already has built-in instructions that says, I'm going to this beneficiary that I see on this piece of paper that was filled out and attached to the life insurance policy or the IRA, annuities. Those are the typical things that have beneficiaries. So your will, and again with the little asterisks about a trust, we'll talk about that briefly in a second. Your will is designed to give instructions to things that you own that don't have any built-in instructions. There isn't a joint owner with survivorship. There isn't a beneficiary form attached. You didn't own it in a trust. So if you have a bank account that's just in your own name, no joint owner with survivorship, no beneficiary form, you don't own it in your trust, when you pass away, it doesn't know where it's supposed to go. There's no internal instruction that tells it where to go. It gets instructions about where to go from your will. So we can't just assume that everything that you own is going to get instructions from your will. We have to put everything in the proper column and make sure that everything's going where you think it's going, because if that life insurance policy has a beneficiary form, it says it's going to Susie, and in your will you say, I want my life insurance policy to go to Joe, it's going to Susie. It's never making it to the will to find out that you had changed your mind and you wanted it to go to Joe. So it's really important that we see what you own and how you own it. And the will is there for things that don't have other built-in instructions, a beneficiary or a joint owner with survivorship. The will goes through the probate process in order to work. So the probate process is the court overseeing the will to make sure that your wishes are carried out. Now, people tend to hear the word probate and they say, I don't know much about probate, but I know I'm supposed to avoid it. Not necessarily. Probate's kind of like when your doctor tells you, oh, you need to have this medical procedure. And you go, well, let me kind of Google that medical procedure. Anybody who had a problem with that medical procedure, put a note about it on Google. Anybody who didn't have a problem with that medical procedure got on with their life and didn't put anything on Google. So you get kind of a skewed opinion because people who had a bad experience are quite vocal about it, and people that had a normal experience are not. And so probate is not necessarily bad. You know, it's got pros and cons just like everything else, but sometimes it can be your friend, sometimes it cannot be your friend. So when we're trying to figure out how big of a job do we want your will to have, that's when we're trying to figure out, is this something that's good to go through probate or something that's not good to go through probate? And then the last piece, because I was saying there was 4 ways you own things. So joint owners with survivorship rights, something that you've put a beneficiary form on, something that has no built-in instructions, gets instructions from your will, or something that gets instructions from your trust. And the trust is the last thing that we're going to chat about here briefly. Before then, I'm going to turn it over to Jen, and she'll talk to you about the pet trust. So a trust, think of a trust as like a bucket. Think of little kids running around the beach with their little sand pails, kind of like they're all running around with little trust buckets. What the attorneys create for you, the paper that says you have a trust, that's in essence babysitter instructions. So you have your bucket that you own. We put, let's say, your bank account in your trust bucket, so it's owned by your trust. We put the babysitter instructions that the attorneys create for you in the trust, and the babysitter instructions say, when I pass away, I want whatever's owned in my trust bucket to go to Sally. Well, now that trust bucket kind of operates like a beneficiary designation, because when you pass away, we look in the trust bucket. Attached to the trust bucket is the instructions, or the babysitter instructions that say, give whatever's in this trust bucket to Sally. So what's in your trust doesn't have to get instructions from your will, because it's got built-in instructions just like a beneficiary form does. So that's why things that you put in the trust do not go through the probate process, because the only thing that's going through the probate process are things that are getting instructions from your will. So 4 different ways that things can pass when you pass away. We need to see what you own in which of those 4 columns, so we can figure out how big of a job your will has to do. And most people want to consider putting their own will in place, because otherwise, without a will, if there's something that needs to have instructions from the will, if you haven't put a will in place, you've got the state of Florida option, which, especially when you have a blended family, may not turn out the way that you anticipate. The Florida default option, because there's only one option, it's one size fits all. It's one size, cram everybody in to make it fit all. It's set up for the typical Norman Rockwell, only been married once, have all the children in common families. And if you deviate from that, the built-in instructions may have assets going in directions that are not in compliance with what you would like. So as with anything else, if you take control of it and you put your own wishes in place, you can pretty much have whatever wish you want. In the absence of your wishes, the void is going to be filled in by the state of Florida default plan, because somebody's going to inherit your stuff. And the last thing I'll say in the last 30 seconds is, people are worried that if they don't have a will, that the state of Florida is going to inherit their things. The state of Florida doesn't want your things. The state of Florida is the very last person on the list, on the default list as to who's going to inherit. It's going to go to your second cousin that you've only seen once in your life before it's going to go to the state of Florida. So most people find that comforting, that it's not defaulting automatically to the state of Florida. So, okay, I know that was a whole lot of information crammed into 45 minutes. Jen's going to talk to you now about the pet trust, but just know, if you have a question, you can still type it in, and we'll try to answer it for you.
All right, Stephanie, thank you. That was amazing information, so helpful. And again, please, if you have questions for Stephanie, I'm going to talk a little bit about our Legacy of Love Pet Trust, but she's not going anywhere. So if something comes to you that you didn't ask while she was talking, please feel free to put it in the chat box or that Q&A box at the bottom of your screen. So I'm guessing some of you out there are pet owners. Now we're going to talk about what happens to your furry 4-legged friend in the event that something happens to you and you're no longer able to care for your beloved dog, your cat, your bird, whatever your pet of choice may be. And that's where we come in at SPCA Tampa Bay. We have set up what is called our Legacy of Love Communal Pet Trust. And it's very similar to a standard trust, a traditional trust, in which you would put money into a trust account for a beneficiary. The main difference is ours is a pooled trust. And what that means is multiple people, multiple pet owners invest into this one trust. And within the trust, there are sub-accounts for each of their pets. A couple benefits: it makes it a little less complex to set up. We kind of do the heavy lifting for you. It also makes it a little more cost effective to set up, to get involved with our Legacy of Love Communal Pet Trust. So here's a little bit about how it works. And again, stop me at any point if you have questions. I will do my best to answer them. And if I can't answer it, I will definitely get back to you because I will have your email addresses. So let me pop open, let me share our website. So we're going to talk a little bit about it today, but if you're interested in more information, you can go to our website, which is spcatampabay.org/planning for your pets. And that's where you can find a little bit more information about our pet trust, as well as the document that gets it all started. And that is the pet profile form. So let's use Stephanie as an example. If she came to us and said she was interested in setting up trust accounts in our pooled pet trust for Zoe and Zach, her kittens, what we would do is we'd ask Stephanie to get started by filling out one of these pet profile forms for each animal. Basically, it tells us a lot of things. It gives us your contact information, as well as a proposed guardian or caretaker if you have identified a person to care for your pet in the event that something happens to you. If you have not identified a person, that's okay. That's where SPCA Tampa Bay comes in, and we'll get into that in a minute. And then we need to know all the important information about your pet. So everything from, does the pet have a health condition? Does the pet have any disabilities? Any special habits? What kind of food does your pet eat? Basically, what do you want us to know about your pet in the event that we need to place your pet if something happens to you? So going back, once you've filled out this pet profile form, we do ask our pet trust account holders, or grantors as they're called, to initially fund the trust with $1,000 for each pet that they're setting up a trust account for. That helps us set up the account. It helps us ensure that if there is any holdup with the estate or anything of that nature, that there will be some money to care for the pet in the event that the pet has to come to SPCA Tampa Bay. So when you set up a pet trust account, there's two options. The first one is you've identified a proposed caretaker or guardian right here. That may be a family member, it may be a friend, it may be somebody you know, maybe your neighbor. So you'd give us that information, and we would help to ensure that the pet was properly taken by that person in the event of your death or disability. Now, sometimes the best laid plans don't always work out that way, and maybe Stephanie names me as the guardian for one of her cats. However, in the time that passes between when Stephanie names me as the guardian and when this trust kicks in after something has happened to her, I've gotten a dog, and my dog doesn't like cats. So I can no longer be the guardian for Stephanie's cat. Stephanie, I'm so sorry. I love cats. But
you don't want to have four?
No, I'm sorry. I can't help. So in that event, what would happen as a person who's got a trust account through our Legacy of Love Pet Trust, we would take your pet here at SPCA Tampa Bay. We would put your pet through all of our adoption protocols. So they'd get full veterinary care while they were here at SPCA Tampa Bay. They'd have food, shelter, behavioral assessment. And ideally, we would determine that that pet was adoptable and could be sent to a new home. What would happen at that point is, because you had set up the trust with your pet as the beneficiary of that trust, that money would follow the pet. So the money is going to follow the pet in either scenario, whether you name your own guardian and that person is able to care for the pet, or if the pet comes to SPCA Tampa Bay and does get adopted out through SPCA. So it's nice because when somebody adopts an animal, when there is a pet trust involved, that animal has sort of a fund to help the new owner care for the pet. Everything from vet bills to food reimbursements. What we do is we then reimburse the new owner or the new guardian of your pet for expenses that come up along the way. And we have a documented form, a process in place to help us do that. Now, I mentioned when you set up a pet trust account within our Legacy of Love Pooled Pet Trust, there is a $1,000 initial funding fee, which happens when you are still alive, still able to care for your pet. And then what happens in the event of your passing or a significant disability, which would not allow you to care for the pet, we do ask, we have a minimum funding per pet of $10,000. So your estate would then fund that $10,000 to complete the trust account. That $10,000 would then follow the pet, whether it goes to a guardian that you have named, whether it comes to SPCA and gets adopted out through our process. One thing that people will ask me often is, well, what happens if I set up a trust account for an animal that I have now, and unfortunately that animal predeceases me? Then what happens to the money in that account? So we do have the ability to reassign that account to another animal. So if you adopt another animal, whether it's from us, whether you buy an animal, whether you adopt from another shelter, we can assign that trust account, that existing trust account, to that new animal that is in your home, your new pet. So that allows for a lot of flexibility in terms of making sure that that trust will follow the pet that you have when again you are no longer able to care for the pet. I wanted to touch on, oh, and then in the event that, the one thing I haven't touched on yet, in the event that that pet passes away and either you are still living and you have not gotten a new pet, or you have passed away, you've predeceased your pet, that money in that trust account then comes to SPCA Tampa Bay as a donation to help us in the work that we do, positively impact the lives of animals in our community and the people who love them. So really, by setting up an account in our Legacy of Love Pet Trust and planning for your own pet, you are also helping us. Any residual funds in that account, once the new guardian had been reimbursed, any residual funds would then come to us as a donation. So you're planning for your own pet and you're helping homeless pets at the same time. So that is pretty much the Pet Trust in a nutshell. What questions do you have? Anything that I haven't covered? Okay, I see a question that has come in, but I'm thinking it is better answered by Stephanie. Let me just check the chat box real quick. I don't see anything in our chat box that has come in relative to our pet trust. So, and again, I'm not going anywhere. So if a question comes up, you're more than welcome to put it in the Q&A or chat box about our pet trust. You can also follow up with me afterwards. You should all have my contact information. So Stephanie, I see a question that's come in from Deanna, and it is a somewhat long one. So I'm going to read it. If you need me to repeat any part of it, let me know.
Okay.
Survivorship. Is there a standard list of assets that qualify for survivorship in the state of Florida? You mentioned home, deed. What about purchases like automobile, boat, jewelry, tools, machinery? And then,
oh, go ahead.
There's more to that question, but I will let you answer that piece.
Okay, so the survivorship is think of it like a contract. It has to be something that has some sort of contract aspect. So it could be real estate because the deed acts as the contract. It could be a bank account because the paperwork used to set up the bank account can be a contract. DMV in Florida does allow you to set up your car title to have an automatic beneficiary. So those types of things that have a contractual type instrument that creates them have possibilities to be set up as survivorship. Personal property, like the paintings in your house, your jewelry, things like that, they tend to be individual because you're not typically buying them using some type of contractual type instrument. So hopefully that answered the question. If not, we have time for you to do a footnote.
So Stephanie, she goes on to ask, is it automatic to the spouse or does it go through a division of spouse and children? You mentioned that the state of Florida uses the Norman Rockwell family version.
Oh my gosh, it depends. So for things that are getting instructions from the will, anything that falls in that column, and you don't have a will, it depends upon whether the children that you have are all children that you had with your current spouse, or whether there are children that you have who are not children of your current spouse. So if everybody's Norman Rockwell, one spouse, all the children are in common, it tends to go to the spouse first and then to the children. If we've got any children that aren't in common, now it starts to get a little bit more complicated, because now, depending upon what the asset is, 50% of it might go to the spouse and 50% of it might go to the children, which may not be what you were thinking, because you might have been thinking, I really want to take care of my spouse first. So definitely, if you've got a blended family, you probably do not want to go with the default option. So yeah, they don't have multiple default options. It's just one default option, and it usually gets a little sticky when you've got children who are not common children between you and your spouse.
Awesome, thank you. It looks like another question has come in. It's actually come in from both Deanna and Patricia and Michael, but it's phrased a little differently. So Patricia and Michael ask, if you put everything into a trust, do you still need a will, and why?
Yes, even when you have everything in the trust, you still have a will, and the will's job is to say, if I pass away with anything unexpectedly falling into this column needing instructions from the will, the beneficiary of my will is my trust. So send it over to the trust for distribution instructions. And the reason you always have this will as a backup is because as attorneys, we live in the world of what if. So the what if that prompts you to still have this will is, what if right before you die, you play the lottery, you win the lottery, and you go, yay, and you go out to Tallahassee and you get your check. But before you can come home and deposit that check into your nice bank account that's owned by your trust, you get hit by the truck and you pass away with this check that doesn't have any built-in instructions telling it where to go. So it has to get instructions from your will. We want your will to say, send it over to the trust, because I already took a lot of time to say who I wanted to get what. So you always have a will, even if you have a trust. It's just that your will might not, most likely doesn't have as big of a job to do as a will that you would have if you don't have a trust. Hopefully that makes sense.
Thank you. So I do see another question that has come in, and I love it. It's a great question to ask. So it says, I realize that this is SPCA sponsored, but can one just establish some kind of personal trust with instructions for pets? I'm going to start that one and say, absolutely, our communal pet trust is an option. We've set it up to make it perhaps a little less complicated, perhaps lower the barrier to entry a little bit for people wanting to ensure their pets are cared for. But I'm going to toss it over to Stephanie because I think she can get into the real meat of this question.
Yes, so in taking care of your pets, you can do anything from setting up a pet trust to basically just including a paragraph in your will that we call leaving your pet a dowry. So you can say, okay, I want my pet to go to Susie as the new caregiver and give Susie a check for $10,000 to take care of my pet. So we are all assuming that Susie's going to use that $10,000 to take care of the pet. But if the pet passes away the next day, Susie still has that $10,000, which may or may not be okay. Because remember, this gets to be set up any way that you want. For some people, they go, okay, that's fine. Other people say, I kind of want somebody to oversee what's happening to that $10,000. And if my pet passes away the next day, I kind of want that $10,000 to go help another pet. And that's when you set up a pet trust, whether you set up your own or you join a communal one like the SPCA. The SPCA is the only person I know, the only organization I know that has a communal one, because when you go to set up your own pet trust, it takes a lot of people. You've got to have who's the caregiver. You have to have who's going to be in charge of the money. You have to have who's going to oversee both the caregiver and the person who's in charge of the money to make sure everything's working. And a lot of times when people go to set up their own pet trust, they just run out of people. You know, we don't have enough people to make it work. And then you say, well, gosh, these people I'm naming, they're kind of the same age I am. And, you know, maybe this might not work. And so that's why kind of having the SPCA saw this void, this need that some people, this desire that some people had to have the oversight that you get from a trust, but didn't have enough people to put it in place for themselves, and created this option so that you can kind of get the best of both worlds. You can get the oversight that you want. You can make sure the money is used for your pet or another pet, and you don't have to worry about whether someone that you named, you know, died before you, because you've got an organization that you've named.
I'm so glad that question got asked. And Stephanie, I'm really glad that you made that point, that when it is a traditional pet trust, there are not just one person that you need to name, the pet guardian, but the pet welfare checker, the trustee. So it does become a little more cumbersome. That's where we've just tried to simplify it for people who do want to set aside some money to follow their pet. So thank you for that better explanation.
Oh, you know what? You never know. You know, I'm a firm believer that people need to hear different points of view for the explanation, because you just don't know which explanation is going to click. You know, sometimes two people can tell me the same thing, and it takes the second person telling me, I'm like, okay, I got it now.
Absolutely. And that's what we're all here to do, is to kind of learn things that we may not be experts on. So this has been wonderful information. I do see one more question that came in regarding the pet trust. Can you explain when the $1,000 pet trust increases to $10,000? I don't understand the $10,000 aspect. Yes, so that is pretty simple. What happens when you tell us you want to set up the trust account? We ask you to initially fund that $1,000. That gets deposited right into your pet trust account. And then upon your passing, once your estate begins to get settled, that's when the additional $9,000 would come to us to completely fund that pet trust account. So we do ask for the $1,000 up front, but then your estate will handle the rest. And the $10,000 amount that I gave, that is just the minimum that we ask. You can set up a pet trust for another amount if you'd like. So I hope that answers your question. The majority of the funds will come from your estate to fund this trust account. Any other questions? Let me check the chat box. Oh, looks like one person just chatted something. Oh, that was a thank you. Looks like we've gotten a few thank yous and some good information here. So any other questions? We're just a few minutes over the hour. Oh, one more question. Is that per pet? Yes. So our Legacy of Love Pet Trust is set up on a per pet basis. So it is $10,000 per pet that we ask you to fund in our trust sub-accounts. So I hope that helps. Anything else, either related to the Legacy of Love Pet Trust or to what Stephanie has shared with us? Some great information. I know I need to get started. Oh, Stephanie, I do have a question, and it's a simple one. I hear it a lot though. What's a good age? When should I start really planning my estate?
For the things in column number 1, the health surrogate, living will, durable power of attorney, once you turn age 18, because many parents mistakenly find out as their 20-year-old is at college and has a medical event that just as the parent, they no longer have access to that medical information under the privacy rules unless they've been designated the healthcare surrogate by their child. So in that first column, you know, healthcare surrogate, living will, durable power of attorney, probably age 18, because that's all about you and taking care of you. The will, probably once you own something that you care about, where it's going to go when you pass away.
Great. Good. Thank you for that. One last call for questions. If we don't have any, then we will call it a Sunday and hope that the sun has come out here in Florida since we've been on Zoom. I'm not sure that's the case, but thank you all for coming on today, for logging in, for your curiosity about estate planning and our Legacy of Love Pet Trust. But a huge thank you to Stephanie Edwards, our featured presenter today with all of the knowledge. Stephanie Edwards, of course, founded Edwards Elder Law in St. Pete. So if you have any additional questions, I'm sure she'd be happy to assist.
Yes, we're happy to answer questions, because the more information you have, the closer you can get to peace of mind, because you know what you need to do to create your version of peace of mind.
And that's what it's all about, peace of mind, knowing that when you're not here to make decisions, somebody will be making them for you according to your wishes. So, all right, if that's it, we will say thank you for joining and wish everyone a wonderful Sunday afternoon. If you're watching the Bucks game, go Bucks. Have a great day, everybody.
Thank you. Bye.
Bye-bye.